Welcome to my channel, Learn and Earn, to live your life on your own terms. You're welcome to my channel, Learn and Earn Academy. And today in this video, we are going to talk about book summary of Indian Polity written by M. Laxmikant. This is part 2 of 6 video series. These are handwritten notes by someone whose notes are available online, and I would like to thank the person for giving such valuable information to all of us. This video is for educational purposes, so if you like this video, you can press the like button, subscribe to my channel, and share this video on social media. Help us to spread education in this beautiful world. So let us start the part 2 of the book summary. The part 2 of the video series for this book summary. Today we are going to discuss Fundamental Rights Part 3 of the Constitution, Article 12 to 35. Now, Part 3 of the Constitution is described as the Magna Carta of India. Part 3 is also called the cornerstone of the Constitution, and together with Part 4, Directive Principle of State Policy, it constitutes the conscience of the Constitution. They aim at establishing a government of laws and not of men. They are fundamental because they are granted and protected by the Constitution, which is fundamental law of India. They are fundamental also in the sense that they are most essential for all-round development of the individuals. Let's talk about Article 12. Now, Article 12 gives the definition of the state. In this part, unless the context otherwise mentioned, the term state includes Government and Parliament of India, Government and Legislature of India, all local and other authorities, which includes within the territory of India or under the central power of the Government of India. Now, what is Article 13? Now, law inconsistent with fundamental rights. It declares that all laws that are inconsistent with or derogation of any fundamental right shall be void. So, what is the ambit of this law? It is a permanent law enacted by Parliament or state legislature, temporary law like ordinance issued by President or Governor, order by laws, rules, regulations, or notification, non-legislative sources of law, that is custom and its usage having the force of law. Now let's talk about right to equality, which is covered from Article 14 to 18. Let's talk about Article 14. Article 14 says equality before law and equal protection of law. The state shall not deny to any person equality before law and equal protection of law. Person includes citizens and foreigners as well as legal persons. So what do you mean by equality before law and equal protection of law? So equality before law is a British origin concept. It's a negative concept. It prohibits special treatment. It is one of the aspects of rule of law by Professor Dicey. However, equal protection of law is a US origin concept. It's a positive concept. It allows special treatment. It means equality of treatment under equal circumstances. It permits reasonable classification of persons, objects, and transactions by law. So under this rule of law, you must have heard about this quite a number of times on news debates, etc. Now, rule of law means no man can be punished except for the breach of law. Everyone is equal before law. Constitution is result of rights of individuals rather than Constitution being the source of individual rights. So Constitution is not the source of individual rights. It is a result of right of individuals. Now, first and second element are applicable to Indian system, these two. And Supreme Court held rule of law is the basic feature and cannot be amended. Now, what are some of the exceptions? Now, exception is for President and Governor under Article 361, foreign diplomats, that is United Nations Organization, etc. Article 31C says that it provides the laws made by the state for implementing directive principle of state policy contained in clause B or AC of Article 39 cannot be challenged. So let's see what is Article 15, Prohibition of Discrimination on Certain Grounds. It provides that no citizen shall, on the grounds of religion, race, caste, sex, or place of birth, subject to any disability, liability, restriction, or condition with regard to access of shop, public restaurants, hotels, and places of public entertainment, the use of well, tanks, bathing ghats, roads, and place of public resort maintained behali on partially by state fund, on behalf or partially by state fund. Exceptions: special favor for scheduled caste, scheduled tribe, and other weaker sections allowed. Special favor can be given to women and children. Now let's talk about Article 16, which is very important article: equality of opportunity in public employment. No citizen can be discriminated against or be ineligible for employment or office under the state on the grounds of only religion, race, caste, sex, descent, place of birth, or residence. So what is the exception to this article? Parliament can prescribe residence as a condition for certain employment in state or union territory or local authority. Special favor can be given to scheduled caste, scheduled tribe, and other weaker sections. Religion can be ground for discrimination in special cases. For example, appointment of imams in madrasas. Now, what is Article 17? Now, Article 17 means abolition of untouchability. Article 17 abolishes untouchability and forbids its practice in any form. Following acts are offensive as per Protection of Civil Rights Act 1955: preventing any person from entering any place of public worship, denying access to any shop, hotel, or places of public entertainment, refusing to admit persons in hospitals, educational institutions, or hostels established for public benefit, insulting a person belonging to scheduled caste on grounds of untouchability, preaching untouchability directly or indirectly, refusing to sell goods or lend services. Now, what is the punishment if this law or this article is breached? There is an imprisonment up to 6 months or fine up to 500 or both. Convicted person is disqualified for contesting elections to parliament or state legislature. Now, what is abolition of titles as per Article 18? Provisions are as follows. It prohibits state from conferring any title except military or academic. It prohibits a citizen of India from accepting any titles from any foreign state. No foreigner working under the state can receive any title from any foreign state with consent of the President of India, without the consent of President of India. So you cannot take any foreigner working under state can receive any title from any foreign state. Now, Bharat Ratna, Padma Vibhushan, Padma Shri, such awards do not amount to titles, as theory of equality does not mandate that merit should be recognized. Now, what do you mean by Article 19 to 20, which establishes right to freedom? Now, this Article 19, 20, 21, and 22, 4 articles are very important and form the basis of our right to freedom of speech. Now, freedom of speech is defined under Article 19. Originally, there were 7 rights. This is very, very important. From Article 19, 1A to G, however, Article 1F, that is right to acquire property, was abolished and now it has become a legal right. So the 6 rights are right to freedom of speech and expression, right to assemble peacefully without arms, right to form associations or unions or cooperative society, which was added by 97th Amendment Act 2011, right to move freely throughout the territory of India, right to reside and settle in any part of the territory of India, right to acquire property. It was abolished by 44th Amendment Act 1978. A lot of questions can be asked from this. In right to practice any profession or to carry on any occupation, trade, or business. These are some of the very important aspects of this article. Now, right to freedom of speech and expression. This is very important along with Section 66A of IT Act. Every citizen has the right to express his views, opinions, beliefs, and convictions freely by word of mouth, writing, printing, picture, or in any other matters. Now, reasonable restriction on ground of sovereignty and integrity of India, security of state, friendly relation with foreign states, public order, decency or morality, contempt of court, defamation, incitement to an offense. Now, what do you mean by freedom of assembly? It includes right to hold public meeting, demonstrate and take out processions. The right does not include the right to strike. Restrictions on ground of public order and sovereignty and integrity of India, including the maintenance of traffic in the area concerned. Now, what do you mean by freedom of association? It includes the right to form political parties, clubs, companies, partnership firms, society, trade unions, or any body of persons. Reasonable restrictions on ground of public order, morality, and sovereignty and integrity of India. Supreme Court held that trade unions have no guaranteed right to effectively bargain or right to strike or declare lockout. Now, freedom of movement and freedom of residence. Restriction on the ground of the interest of general public and interest of any scheduled tribe. Freedom of movement have two dimensions: internal, inside the country, and external, move outside the country and come back to the country. First dimension is covered under Article 19, second under Article 21. Now let's talk about freedom of profession. Restriction on right and interest of general public, prescribed professional or technical qualification necessary. It does not include right to carry on profession or business that are immoral or dangerous. Now, what do you mean by protection and respect of conviction of offences? Article 20 grants protection under arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person. It contains three provisions. No ex post facto law. It means retrospective criminal legislation. Under this rule, no person can be punished with retrospective effect. This limitation is imposed only on criminal cases, not civil or tax law. Immunity cannot be claimed in case of preventive detention. No double jeopardy. Now, no person shall be persecuted and punished for the same offense more than once. It is available only in proceedings before court of law or a judicial tribunal. No self-incrimination. No person accused of any offense shall be compelled to be witness against himself. It extends only to the criminal proceeding and not to civil proceedings. Now, what do you mean by protection of life and personal liberty, which comes under Article 21? No person shall be deprived of his life or personal liberty except according to the procedure established by law. In case of Menka case in 1978, Supreme Court held that the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. The court held that right to life as embodied in Article 21 is not merely to confine to animal existence or survival, but it includes within its ambit the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete, and worth living. Now, following rights are included in Article 21. This is very important. Right to health, right to shelter, right to privacy, right to decent environment, right to livelihood, right to information. Now, as per these rights, the government tries and plans to bring welfare measures, bring policies which gives freedom to the people in these areas. Now, let's talk about right to education, which comes under Article 21A. The state shall provide free and compulsory education to all children of the age 6 to 14 in such a manner as the state may determine. It made elementary education a fundamental right. It was added by 86th Constitutional Amendment 2002. Before this amendment, Constitution contained a provision for free and compulsory education for children under Article 45 of Part 4. However, it was not enforceable by the courts. In pursuance of Article 21A, Parliament enacted the Right to Children to Free and Compulsory Education Act 2009. Now, protection against arrest and detention, Article 22. Now, there are two different aspects of this Article 22, which is as per the ordinary law and the preventive detention. Now, right to be informed of the grounds of arrest. So, whenever a person is arrested, he needs to be informed on what basis he is being arrested. Right to consult and be defended by a legal practitioner. So, any person who is detained has the right for a lawyer. Right to be produced before a magistrate within 24 hours excluding journey time. Right to be released after 24 hours unless the magistrate authorizes further detention. Now let's talk about preventive detention. Detention can't exceed 3 months unless an advisory board reports sufficient cause of extended detention. Grounds of detention should be communicated to the detentee. This detentee should be afforded an opportunity to make a representation against the detention order. It is not available to alien or person arrested under preventive detention. Now, what do you mean by right against exploitation, which is covered under Article 23 and 24? Now, Article 23 says prohibition of traffic in human being and forced labor. Now, people are being trafficked illegally and are forced to do labor, which is prohibited under Article 23. The right available to both citizen and non-citizens against the state as well as against the private person. Now, traffic, when we talk about traffic in human beings, it includes selling and buying of men, women, children like goods. It is immoral traffic of children, including prostitution. Devadasis is a form of slavery which is prohibited under this act. This article prohibits forced labor. Forced labor includes compelling a person to work against his will. No remuneration for work done. Remuneration less than minimum wages prescribed by the government. Bonded labor system, Abolition Act 1976. The Minimum Wages Act 1948. Contract Labor Act 1970 are the actions taken by the government to prohibit forced labor. Article 23 exempts state to impose compulsory service for public services. Now, what do you mean by prohibition of employment of children in factories, etc. under Article 24? Now, it prohibits the employment of children below the age of 14 years in any factory, mine, or any other hazardous activities. It does not prohibit their employment in any harmless work. However, later government puts total ban on child labor. Now, let's talk another aspect of our constitution, which is right to freedom of religion, which is covered from Article 25 to 28. This article is what makes our country a unique nation, which respects all the religion, caste, creed, and color. Now, freedom of conscience and freedom of profession, practice, and propagation of religion, as per Article 25, it is very important. Now, the implication of this right is freedom of conscience, right to profess, right to practice, right to propagate. Now, subject to public order, morality, health, and other provisions relating to fundamental rights. Further, the state is permitted to regulate or restrict any economic, financial, political, or other secular activities associated with religious practice. It also provides for social welfare and reform and throw open religious institutions of public character to all classes and sections of Hindus. Now, freedom to manage religious affairs, Article 26. Every religion, denomination, or any of its sections shall have the following rights: right to establish and maintain institutions for religious and charitable purposes, right to manage its own affairs in matters of religion, to own and acquire movable and immovable property, to manage such property in accordance with law. Now, freedom of taxation for promotion of religion, Article 27. Now, no person shall be compelled to pay any taxes for promotion or maintenance of any particular religion or religious denomination. This prohibition prohibits state from favoring, patronizing, and supporting one religion over the other. This provision prohibits only levy of tax and not a fee. Now, what do you mean by freedom from attending religious institution? Article 28. Now, according to Article 28, educational institutions are classified into 4 categories. Institutions wholly maintained by the state. Institutions recognized by the state. Institutions receiving aid from the state. Administered by state established under any endowment or trust. Now, in religious institutions is completely prohibited, while Section 2 and 3 religious instructions is permitted on voluntary basis. In 4, serial number 4, administered by state established under any establishment of trust, religious instruction is permitted. Now let's talk about cultural and educational right, which comes under Article 29 and 30. Now, protecting of interest of minorities, Article 29. Any section of citizens residing in any part of India having a distinct language, script or culture of its own shall have right to conserve the same. No citizen shall be denied admission into any educational institution maintained by state on grounds of religion, race, caste, or language. It protects both religious as well as linguistic minorities. Now, right to minorities to establish and administer educational institution, which comes under Article 30. All minorities shall have this right. The compensation amount fixed by state for compulsory acquisition of any property of a minority educational institution shall not restrict the right guaranteed to them. In granting aid, the state shall not discriminate against any educational institution managed by minority. Now, right to constitutional remedies, Article 32. Now, Supreme Court has ruled that Article 32 is a basic feature of the Constitution. It contains following 4 provisions. Right to move to Supreme Court by appropriate way for enforcement of fundamental right. Supreme Court shall have the power to issue directions or writs for enforcement of any form of fundamental right. Parliament can empower any court to issue directions, orders, and writs of all kinds. Right to move to Supreme Court shall not be suspended except as otherwise provided by the Constitution. Now, we will study types of writs. Now, this is very important. Now, the first writ, which is called habeas corpus. Now, it means to have the body, which means to be produced before the court physically or bodily. This writ issued to protect personal liberty of individual as given in Article 21 from illegal detention. Now, this writ is issued against the state as well as private individual. The second type of writ is called mandamus. It literally means we command. This writ is issued against public official, public body, corporation, inferior court, tribunal, or government asking them to perform their official duties. However, it cannot be issued against private individual or body, president and governor, chief justice of high court. Prohibition. It means to forbid. It is issued by higher court to lower court or tribunal to prohibit subordinate courts from initiating or continuing proceedings in any particular case. Not available against administrative authorities, legislative bodies, and private individuals. The third writ petition is called certiorari. Now, it means to be certified or to be informed. It is issued by higher courts to a lower court or tribunal either to transfer a case pending or squash the order of lower courts. It is issued on the grounds of lack of jurisdiction or excess of jurisdiction. The fourth writ petition or writ is called quo warranto. Literally means what is your authority. It is issued by a court to inquire into the legality of claim of a person to a public office. This writ can be issued only in case of substantial public offices, not against ministerial or private office. Now, what is Article 33? According to this article, Parliament is empowered to restrict and modify fundamental rights of certain categories of armed forces. Article 34. This article empowers Parliament to identify a person or restrict his fundamental right in case of marital law is declared in any part of territory of India. Article 35. According to this article, it is the power of the Parliament and not state legislature to implement fundamental right by making laws. Now, rights outside parliamentary. No tax shall be levied or collected except by authority of law. Article 265, Part 12. Right to property. Article 300A, Part 12. Trade, commerce and intercourse throughout the territory of India shall be free, which is as per the Article 301, Part 13. Now let's talk about another important aspect of Constitution, which is called directive principles of state policy. Now this is part 4 of the Constitution and is covered from Article 36 to 71. Now let's talk about Article 36. Now Article 36 gives the definition of state, same as part 3. Article 37. Directive principles are non-justiciable but fundamental in governance of country. So these rights cannot be taken to court. Article 38. It is the duty of the state to secure welfare of the people, minimize inequalities in income status, facilities and opportunities. Article 39. The state shall direct its policy to secure right to adequate means of livelihood for all citizens, equitable distribution of resources of the community for the common good, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, reservation of health and strength of workers against abuse, opportunity for health development of children. Now, Article 39A talks about equal justice and free legal aid to the poor. It was added by 42nd Amendment Act 1976. Let's talk about Article 40. Organization of village panchayats to function as units of self-government. Article 41. Right to work, to education and to public assistance in case of unemployment, sickness and disablement. Article 42 talks about provision for just and humane condition for work and maternity relief. Article 43 talks about promoting cottage industries and individual and cooperation in rural areas. Article 43A talks about participation of workers in the management of industry. It was added by 42nd Amendment Act 1976. Let's talk about Article 43B, Organization of Cooperative Society. It was added by 42nd Amendment Act 1976. Article 44, Uniform Civil Code for citizens throughout the country. Article 45, it provides early childhood care and education for all children below the age of 6 years. Earlier it was 6 to 14 years, which was amended by 86th Amendment Act 2002. Article 46, Promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker section of the society. Article 47, Raise level of nutrition and standard of living and to improve public health, prohibition of consumption intoxicating drinks and drugs. Article 48, Organization of agriculture and animal husbandry, prohibition of slaughter of cows, calves and other milch and drought cattle. Article 48A, Protection and improvement of environment and safeguarding of forest and wildlife. It was added by 42nd Amendment Act 1976. Article 49, Protection of monuments, palaces and objects of national importance. Article 50, Separation of judiciary from executive and public services of the state. Article 51, Promotion of international peace and security. It promotes international peace and security, maintain just and honorable relation between nations, foster respect for the international law and treaty obligation, encourage settlement of international dispute through arbitration. Now, these are some of the important articles which we need to remember. Socialist principles and directive principle of state policy is covered under Article 38, 39, 39A, 41, 42, 43A, 45. Gandhian principles and directive principle of state policy is followed by Article 40, 43, 45, 46, 47 and 48. Western liberal principles are covered under Article 44, 45, 49, 50 and 52. Now, directive principle of state policy outside Part 4. It claims of scheduled caste and scheduled tribe to services, Article 335. Instruction in mother tongue, Article 350A. Development of Hindi language in Article 351. Now, these are some of the important aspects. Now, let's talk about Part 4A, Article 51A. Now, original constitution doesn't contain fundamental duties. They are incorporated in our constitution on recommendation of Swaran Singh Committee, report by 42nd Constitution Amendment Act 1976. In starting 10 duties, A to I, later in 2011 duty was added. So what are the fundamental duties which was added by 76th Constitution Amendment? First, to abide by Constitution and respect its ideal national flag and anthem, to cherish and follow noble ideas that inspired national struggle for freedom, to uphold and protect sovereignty, unity and integrity of India, to defend the country and render national service, to promote harmony and spirit of common brotherhood, to value and preserve the rich heritage of country's culture, to protect and improve the nature's environment, to develop scientific temper, humanism and spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres, to provide opportunity for education to his child or ward between the age of 6 to 14 years. It was added by 86th Constitutional Amendment Act 2002. They are not justiciable in nature. Now, fundamental duties are non-justiciable in nature, that is, they cannot be taken to court and fought. They refer to such values which have been a part of the Indian tradition, mythology, religion and practices. They essentially contain just a codification of tasks integral to the Indian way of life. Now, let's talk about the most important aspect of Constitution, which is called amendment of Constitution. What are the procedures of amendment to the Constitution and how our Constitution can be amended? Now, the procedure for amendment is described under Article 368 of the Constitution. It can be introduced in either house of the parliament and not in state legislature. No need for prior permission from the president. It can be introduced by minister or by a private member. The bill must be passed in each house by a special majority, that is more than 50% of total membership of the house and majority of 2/3 of the member present and voting. Each house must pass the bill, no provision of joint sitting. If bill seeks to amend federal provision, note 1 of the Constitution, it must also be ratified by the legislature or half of the state by a simple majority, that is members present and voting. After duly passed by both houses and ratified by state legislature, the bill is presented to the President for assent. President must give his assent. He can neither withhold his assent nor return the bill for reconsideration. Now let's talk about some of the important aspects which we need to remember. Election of President and its manner. It can be in fact, it has been a Supreme Court and High Court. Power of Parliament to amend Constitution, Article 360 itself. 368. Any of the list in 7th schedule. Representation of state in Parliament. Distribution of legislative powers in Union and state. Now, amendment of Constitution can be only introduced for the purpose of either house of the Parliament, not in the state legislature. It can be introduced either by a minister or a private member and does not require prior permission of the President. We have already discussed this. Now let's talk about some of the ways of getting the amendment passed. Types of amendment. Amendment by simple majority of the Parliament, amendment by special majority, amendment by special majority and ratification of half of the state legislature. So let's talk about how does the amendment of by simple majority includes. Now, admission or establishment of new state can be done by a simple majority. Formation of new state, citizenship, which is acquisition and termination, salaries and allowances of MP, and so on. So, what are the cases where you require special majority? Amendments in fundamental rights, amendment in directive principles of state policies. These are the places where you require special majority. Amendment by special majority plus ratification. We will see the important aspects of it. Election of president and its members, Supreme Court and High Court, distribution of legislative power between union and state, representation of states and parliament, any of the list in 7, schedule power of parliament to amend the constitution and its procedure itself. Now, this part of the video will form the introduction to parliamentary system. Now, this is the system which we follow in India, which is to have a parliamentary system of democracy. So what is parliamentary system of democracy? We are going to learn in this video. Now, Constitution of India provides for parliamentary form of government both at center and state. Article 74 and 75 with parliamentary system at center, and Article 163 and 164 in states. Parliamentary government is one in which executive is responsible to the legislature for its policies and acts. The presidential system of government in which the executive is not responsible to the legislature for its policies and acts. Parliamentary government is also known as responsible government. It is also called cabinet system. Responsible government because as cabinet is accountable to parliament and stays in office so long as it enjoys confidence. It is told as cabinet system because cabinet is a nucleus of the power and parliament system. Now, what are the features of parliamentary government? Nominal and real executive. Now, president is the nominal executive and prime minister is the real executive. Prime minister is the head of the government and president is the head of the state. This is important. Majority party rule, which means president appoints the leader of majority winning party as prime minister. When no single party gets majority, a coalition of parties may be invited by president to form the government. Collective responsibility. Ministers are collectively responsible to the parliament in general and Lok Sabha in particular. This is clarified in Article 75. Now, what do you mean by political homogeneity? Now, members are of the same party in Council of Ministers. They share the same ideology. Now, this is very important. Now, imagine a political party who is in power and the members don't have the same ideology. The government cannot run. Double membership. Minister and member of parliament. To become minister need to be a member. Leadership of prime minister. He is the leader of council of ministers, leader of parliament and leader of party in power. Now, what do you mean by dissolution of lower house? President can dissolve the parliament on recommendation of prime minister. What are the reasons for adopting parliamentary system? Why India adopted the parliamentary form of system? Why? Because we already were familiar with the system. Preference was to be more responsible and have more responsibility. Need to avoid legislative executive conflicts. Nature of Indian society. Now, what are the merits and demerits? Now, this is important as we all need to understand the merits of parliamentary form of system is harmony between legislature and executive. It is a responsible form of government. It prevents despotism. It's wide representation. And what are the demerits of parliamentary form of system? It is unstable. If you do not get complete majority, you will get coalition government, which will definitely be not good for the country because they will not be able to take decisions. No continuity of policies, against separation of powers, government by amateurs. Now, we will talk about another form of democracy which is called federal system. So, India is a very unique nation in which we have a mix of both parliamentary form of government and federal form of government and decentralization. Federal means having the central control. So what do you mean by the federal form of system or federal system? Now, federal features of the constitution means dual government, that is at the union, at the center and states at the periphery. We have a written constitution, division of powers between center and states, that is union list, state list and concurrent list. Supremacy of the constitution, that is constitution is supreme or is the highest law. A rigid constitution, that is it cannot be amended easily. Independent judiciary. Bicameralism, that is upper house and lower house. Upper house represents the states and lower house represents the people of India as a whole. Now, what are the unitary features of the constitution? This is important. We have single citizenship in a country, single constitution for both union and states, strong center. There are more subjects in union list. More important subjects are included in union list. Residuary powers are left with the center. Some of the other important features, we have a flexible constitution. Power of governor to reserve the bill passed by the state for the consideration of president, that is the veto power. We have emergency provisions, we have an integrated judiciary, we have appointment of governor by the center, power of parliament to create all India services. Parliament has the power to make laws on state list subject, which is defined in Article 249, 252, 253, 352 and 356. Now let's talk about emergency provision, which forms a very important part of our constitution, which comes under the part 18th of the constitution, covered under Article 352 to 360. Now, what is the rationale behind incorporation of these provisions in constitution? It is to safeguard the sovereignty, unity, integrity and security of the country. National emergencies, Article 352, grounds of declaration. President can declare a national emergency due to external aggression, war or armed rebellion. It was added by 44th Amendment Act 1978. National emergency declared on the ground of war or external aggression, it is called external emergency. When declared on grounds of armed rebellion, it is known as internal emergency. Proclamation of national emergency may be applicable to entire country or any or a part of it. 42nd Amendment Act 1976. Now, President can proclaim a national emergency only after receiving a written recommendation from the Cabinet. As per Minerva Mills case 1980, proclamation of national emergency can be challenged in the court on the grounds of mala fide or that the declaration was based on irrelevant facts. Now, proclamation of emergency must be approved by both the Houses of Parliament, that is, within 1 month from the date of issue. If proclamation is issued at a time of dissolution of Lok Sabha or dissolution takes place during the period of 1 month, then the proclamation survives until 30 days from the first sitting of Lok Sabha after its reconstitution, provided it has in the meantime approved it. If approved by the Houses, the emergency continues for 6 months and can be extended to an indefinite period with an approval of Parliament for every 6 months. Now, resolution approving proclamation must be passed by either House by a special majority, that is, majority of total membership and 2/3 of the members present and voting. Now, what do you mean by revocation of proclamation? It may be revoked by President at any time by a subsequent proclamation. If 1/10 of members of Lok Sabha give a written notice to the Speaker or President if the House is not in session, a special sitting of House should be held within 14 days for the purpose of considering a resolution disapproving proclamation. It needs simple majority. Now, what is the effect of national emergency? Now, this aspect needs to be covered importantly as well. Effect of central-state relationship. Executive, during national emergency, the center becomes entitled to give executive directions to state on any matter. Legislative, during emergency, Parliament becomes empowered to make laws on any subject mentioned in the state list. However, legislative power of the state legislature is not suspended. The laws made by Parliament on state subjects during emergencies, national emergency, becomes inoperative 6 months after emergency ceased to operate. It not only state where national emergency is in operation but also for any other state. Now, financial president can modify constitutional distribution of revenue between the center and state. Such modification continues till the end of the financial year in which the emergency ceases to operate. Now, effect of life of Lok Sabha and State Assembly. Life of Lok Sabha may be extended beyond 5 years by a law of parliament for 1 year at a time for any length of time. This extension cannot continue beyond a period of 6 months after emergency ceased to operate. Same provision for State Assembly, that is 1 year and 6 months after cessation. Now, what is the effect on fundamental rights of emergency? Now, suspension of fundamental rights under Article 19, which is covered by Article 358, suspension of other fundamental rights except Article 20 and 21, which is defined in Article 359. Article 358 suspends fundamental right under Article 19 only in the case of war or external aggression, not on the ground of armed rebellion. Article 359. As per Article 359, fundamental rights are not suspended, only enforcement is suspended. Not all rights, but only those which are mentioned in the proclamation order for a period mentioned in the order will be suspended. Now, these are some of the important aspects of the Constitution which we all must know, understand, and remember. If being as civil servants and applying for major competitive exams in state, you need to have these important points. And the reason I have made this video for all of you is to have quick revision and get most of the important points from this amazing book on your fingertips. So whenever you get time, take out that time and revise, go through this video, read all the articles, make your own notes. And you can also play this video while you are walking down the road or doing your exercise. The more you listen to this video, the more clarity you will get about our Constitution and the entire Indian political system. So let us cover the precedent rule, which comes under Article 356. It is also known as state emergency or constitutional emergency. Precedent rule can be proclaimed under Article 356 on two grounds. Article 356 empowers President to issue proclamation if he is satisfied that a situation has arisen in which state government cannot be carried in accordance with the provision of the Constitution with or without government report. Article 365 says that whenever a state fails to comply with or give effect to any directions of the center, it will be lawful for the President to hold the situation has arisen for the Precedent rule. Now, proclamation must be approved by both houses within 2 months from date of its issue. If approved by both the houses, Precedent rules continues for 6 months. It can be extended for a maximum period of 3 years. Now, the approval is passed by simple majority. Beyond 1 year, Precedent rule can be extended by 6 months at a time only when the following two conditions are fulfilled. So, what are these two conditions? Proclamation of national emergency should be in operation in the whole of India or whole or any part of state, and general election of legislative assemblies cannot be held on account of difficulty. A proclamation of President rule may be revoked by President anytime. Now, what are some of the consequences of President rule? President can take up functions of the state government in powers vested in the governor. President can declare that the powers of state legislature are to be exercised by the parliament. He can take all other necessary steps, including the suspension of constitutional provisions relating to any body or authority in state. During suspension, President can promulgate, when Parliament is not in session, ordinance for governance of the state. Parliament can delegate the power to make laws for the state to President or any other authority specified by him. Law made by Parliament or President or any other specified authority continues to be operative even after President rule. This means that the period for which such law remains is not coterminous with the duration of the proclamation, but it can be repealed or altered or reenacted by the state legislature. President proclamation imposing President rule is subject to judicial review. So I'm sure these aspects of our constitution would not only be quite fascinating to you, but also will give you a lot of understanding about how our constitution actually frames these basic modalities of functioning of government. So let's talk about financial emergency, which is another aspect and very important. Article 360. Article 360 empowers President to proclaim financial emergency if he is satisfied that situation has arisen due to which financial stability or credit of India is threatened. Now, proclamation must be approved by both the houses within 2 months. There is no maximum period prescribed for its operation. Repeated parliamentary approval is not required for its continuation. Resolution approving proclamation can be passed by either house by a simple majority. Proclamation can be revoked by President anytime. It is subject to judicial review. I'm sure this video would have certainly given you a lot of insight and added value to your knowledge, and I'm sure you'll be able to get good marks and clear your exam. So if you like this video, you can press the like button, subscribe to my channel, and share this video on social media. Help us to spread education in this beautiful world. Thank you.